I'm excited today to introduce our speaker, who is an experienced attorney. And if you had the opportunity of joining us last session, then you would have gotten some great tips. And if you haven't, again, we can always send you the recording. All right. So now we are going to introduce Callan Soldavini. So Callan is a public interest attorney. She is dedicated to helping those with unmet needs. Through her career, she has worked as a transactional business attorney and a civil prosecutor. So Callan wears a lot of hats in the community, and she's an advocate for the underserved communities. She is a teacher, so she's an instructor, so she teaches courses in ethics, business law, corporate social responsibility, and conflict resolution. She now works at the FCDL as an attorney and at the legal aid of Collier County and Broward County. And I'm really happy to have her here again to join us for this program. She's been such a great help with everything, and she is such a great resource. So if you don't mind, Callan, you can take it from here. And you can unmute.
Hi everybody, my name is Callie and I am very excited to be presenting today on the differences between the 4 types of business entities, and then a little bit about DBAs, or what Florida statute calls fictitious names. I'm going to share my screen here with our PowerPoint. A little bit about why I'm presenting and my program. As Sidoni said, I work for the Florida Community Development Legal Team, FCDL, and we represent small businesses and nonprofits free of charge. So we do various types of legal services, including most commonly contract drafting, contract review, client template agreements, lease drafting and review, trademarks, partnership agreements, really anything you can think of outside of the courtroom that comes up for your business, either from a day-to-day basis or some kind of document it needs when it starts. If you're new to business or you're sole proprietor partnership looking to register your business, this presentation is going to be on point. And what we're really going to focus on is the differences in liability between sole proprietorships and partnerships on the one hand, and corporations and LLCs. And so if this is something that you're interested in doing, again, this is the kind of representation we provide free of charge. And to be eligible to receive these free services, all of the business owners have to be what's determined low to moderate income, which is up to 140% of their area median income. And that is a pretty big window we get to play with. So for a family of 1, it's about $70,000. For a family of 4, it's about $90,000. So even if you're on the cusp of that and you still think maybe you make slightly over, we'll really try to get you into those qualifiers depending on what your business does, where it's located, and who it serves. So even if you think you're close, go ahead and reach out. And one last thing is, if you have several owners, all of the owners have to be low to moderate income. So again, clients, we don't represent any individuals, only small businesses and nonprofits, free of charge. And today I want to talk to you about those 4 different business entities, but all of the information in this presentation is intended to convey only general information. So whatever is going on in your specific business is an individual problem, and I wouldn't rely on the contents of this presentation, but rather consult or retain a qualified attorney or maybe even a financial advisor to discuss your specific matter. So everything we'll talk to today is a general matter intended to likely apply to the broadest basis. The 4 business entities we'll discuss are, on the one hand, sole proprietorships and partnerships. These are things you don't need to register with the state. And on the other hand, limited liabilities and corporations that you do have to register with the state, but gives you a lot of liability protection and other benefits. And generally, especially when a client comes to me, the first thing I'm going to do is ask them to send me a business plan, because to know which one of these is best for you, I'm going to need to understand what your business is doing, what kind of, how much money you have, if you're profitable yet, what kind of liability the business is taking on, tax ramifications. So really putting pen to paper and taking the time to write a business plan, which we discussed for those of you in our webinar 2 weeks ago, is a really important first step to figure out exactly which business entity is going to be best. Most generally for my small business clients that are sole proprietors looking to make that transition to a registered company, either an LLC or corporation, it's generally best to be an LLC taxed as a sole proprietor. So you get the liability protections, but you get the ease and simplicity of filing one tax return. So we'll talk a little bit about taxes and how they affect these 4 business entities today as well. So what your business plan will tell yourself or me, if any representation occurs, is what kind of liability is associated with the business? What's your personal financial situation? Are you capable of paying incorporation filing fees that the state requires at this time? What are the goals of the business? And finally, what are some tax considerations that you may want to consider before electing? The first business type is a sole proprietorship. So anyone in the room that has a business, they're the only owner, they're the only ones that actually have ownership rights in the business and have done nothing like register with the state, then you're by law acting as a sole proprietorship. It doesn't require registration or incorporation with the state. It's owned by a single individual, and because there's no registration, there's no distinction between the individual business owner and the business itself. So in the eyes of the law and in the eyes of IRS, your business and you are one single person. Finally, the individual name of the business has to be the sole proprietor's actual legal name. So if you are operating, if your name is John Smith and you're operating ABC Company, you actually have to register that fictitious name, ABC Company. In other words, you can only operate under your individual name. So if that's something you're doing, you're definitely going to want to go to sunbiz.org, and I'll bring this up again at the end of our presentation. It's a $50 filing fee for a fictitious name. Again, using a business name that's not your individual name. Only if you're a sole proprietorship, this applies. And make sure that that fictitious name is registered. And then really the point of this is so that you put all of your clients and all of potential consumers on alert that that business is the same thing as your sole proprietorship. And it's just something we require under Florida statute, and certainly a mess you don't want to get in if any kind of litigation or liability arises in your business. So there's very rarely a circumstance that I would advise a sole proprietorship is the best business formation. Same with partnerships. I'm always going to recommend, generally always going to recommend that an LLC or corporation is best, because rather than have all of the liability for the business invested in just you individually, it's going to separate you individually from your business, and therefore any liabilities that you have in your business, creditors can't come after you personally for the most part. So again, the sole proprietorship liability, to put it clearly, is if your business incurs any kind of debts that it cannot pay from its profits, you personally, the sole proprietor, are liable and responsible for payment. That's a lot of responsibility. So creditors can sue you personally to satisfy the debt and collect from your individual assets. Maybe a car that you're driving, a bank account with cash in it. It's not separating the business liabilities, because essentially under the eyes of the law, a sole proprietor is the same as a business. one single entity. With other entity structures like the corporation or LLC that we'll dive into, you do have to pay attention to some more formalities, but you are not personally liable. Your business is. Similar, like a partnership or a sole proprietorship is a partnership. It's pretty much the same thing as a sole proprietorship, but instead of one person, it's two or more individuals carrying on a business as co-owners and sharing in the profits. So if you're working with someone in a business and there's where you're sharing in profits and you're both managing the business, but you haven't actually registered your business with the state, then law is going to interpret that you're a partnership. When there's a partnership or anything you're doing with more than just yourself, you should create a partnership agreement. And this is something we got into more in depth with in our webinar 2 weeks ago relating to written agreements. A partnership agreement spells out the details of the partnership. And if one is not created, Florida statute will impose terms on you and your partners that may not be what you intended. Moreover, I just added this slide. Moreover, you may have to even prove that you're part of a partnership. This is going to come anytime that you're doing business with more than one person. You should have this internal operating document that lists exactly how they got into the business, meaning what kind of work or what kind of skills or what kind of investment did they give the business in order to be a part of it, and what's their percentage of ownership. Because if you don't have something like that written down, it's very difficult to prove. And even if you and your partners think you have an understanding mentally, but it's not written down on paper, it is extremely hard to prove. For example, I'm having a client right now that is having to prove his ownership in a partnership, and we're having to go through the website and show that he was a founder of the business. He's having to backtrack bank statements from 8 years ago that he can no longer find to show that he made an initial capital contribution in the business. And it's just so unfair. So the best thing you can do when you're doing business with more than one person, whether it's a partnership, LLC, or corporation, is have an internal operating document that documents exactly how that partner began, what they put in, what their skill set is, what they're expected to do every day, and what their percentage of ownership is. So again, for a partnership, that's called a partnership agreement. For LLCs and corporations, it's called something different, but inherently the same, spelling out the details of the partnership. So a few things that would be included specifically related to partnerships would be duties and responsibilities of each partner and what partners are responsible in day-to-day management. So if someone doesn't have the authority to enter into a contract on a partnership, that's definitely going to need to be something written in the partnership. How and when capital contributions are made. Was there a source of funds that a partner put up at the beginning? Are they expected to do that in another year? How much each partner is paid? How vote ties are decided, especially if there's only two people in the partnership. When I said that Florida statute imposes certain terms, that's when they're going to impose that each partner, no matter how much money they put in or how much responsibility you have, under Florida statute, each partner has a 50-50 choice. Therefore, if there's two partners and there's a tie, it's almost as if the partnership has to dissolve unless they can negotiate a way out of it. And that's probably not what you intended. So maybe putting in there if there's two partners and that's what you intended, 50-50 vote, who gets the tiebreaker? Or is it 60-40? You want to put it in the partnership agreement so Florida statute doesn't impose those terms on you. And finally, how income taxes will be split and paid. Is someone responsible for more income taxes? Is someone responsible for putting them together on behalf of the partnership? How will the partnership be taxed? And without a partnership agreement, Florida statute chapter 620, you can look at it. It's actually very user-friendly and readable, are the terms that will be imposed if a partnership agreement isn't created. To briefly review again, partnership liability is different, just like an LLC, and different from an LLC or corporation, because the business is not separate from its owners. In the eyes of the law, the business and the partners are one concept. Partners share ownership and liability, all partners. Again, unless said otherwise in your partnership agreement. Partners have unlimited personal liability for partnership debts. So if your partnership maybe leases a big commercial space and that partnership, because of COVID, was no longer able to pay the rents due, then rather than the partnership having to file bankruptcy, and bankruptcy is certainly an individual option, but rather than the creditors or the landlord coming after the partnership, he's going to go a step further, or she, and come after all of the partners individually. So any assets they have in their personal and family life will also be something that the partner can expose, the creditor can attach to. So that's what I mean with liability protection. Rather than a partnership or sole proprietor, if we actually register our business with the state, the law will see the business and our individual selves as separate legal entities. Finally, the partnership income tax is not paid by the partnership. Rather, the profits and losses are passed through and paid by the partners on their individual tax returns. So just keeping in mind those tax ramifications, and really a great investment for any in business is having a tax professional that can tell you the best way that these entities should be taxed.
And Callan?
Yes?
I know you don't mind questions coming in
Please.
at the point when you're covering. I have a question that came in that specifically speaks about partnership. They're asking. So for the internal contract for partnership, do we have to send it to the state?
For what do you, a contract?
Yes. So
or the partnership agreement?
The partnership agreement. I believe that's what they're asking.
Yeah. So the partnership agreement or any internal operating document is something that will only stay within the business. So you don't have to actually register. You don't have to, it's all private. Therefore, only the individuals or entities or third parties you share that partnership agreement with will have knowledge of what's in there. And if you want to keep that knowledge of what's in the partnership agreement confidential, then you can always enter into an NDA, a non-disclosure agreement that, you know, any individual you're negotiating with can't share the contents of that partnership agreement.
Okay, great. And Callan, does this need to be notarized if an attorney wasn't involved? How does that work? How do they make it official?
No notary required. I would just have, you can have one if that's something that's a concern. You always can add a notary to anything, but under Florida statute, it's not required. So just signing the partnership agreement and making sure all partners have a copy of it, so that if the partnership agreement ever does come into question, which certainly could be well into the future, 10 years from then, everyone's like, well, wait, what did I put in? What were my capital contributions? Why is my percentage of ownership this instead of that? Making sure all the partners have a copy and that it's signed is all you need. But if you feel that a notary is something that will make you more comfortable, you can do that, but it's not necessary under Florida statute.
Thank you.
And yeah, please feel free to ask questions. I feel like it's better to get those when we're on a topic rather than at the end. So feel free to interrupt me now. Sidoni will interrupt me and ask those questions. Or if you'd like to save them for the end, I'm going to stay as long as needed to answer all questions. So really the meat of today's presentation, the whole purpose of it is to differentiate sole proprietorships and partnerships with limited liabilities and corporations. Because the difference is that LLCs and corporations must register and pay a fee with the state. And in turn for that, they get a lot of legal protection, because I'll keep saying it again and again, it's separating the business from the individual. So the law, when you enter into a contract as a business, an LLC or corporation that is registered with the state, you're entering into it as the business. If you're, for example, sole proprietorship, you're entering into it almost as your individual self. And I can't tell you how many of my clients are people that are sole proprietors and get into trouble. Right now I have one that is a subcontractor. They do cabinets, and they've been really impacted by COVID and had entered a contract as a sole proprietorship. They didn't create an LLC or corporation. And now creditors are going after their car, their second home, They've garnished their bank accounts, their individual bank accounts. But if you register your business, yes, there are filing fees, and yes, there are more formalities that go along with it that we'll discuss you'll have to do. But when a creditor comes after your business for the debts it cannot pay, generally it cannot go after your personal bank account, your personal vehicle that's not, in the business's name, or your home, especially if it's not homesteaded. So it is a huge liability protection. Even if my clients come to me and say, I don't have the $70 to $125 to pay the filing fee, I'll ask them that's the first thing that they need to do with their business, is save that money and be able to register. So I really can't think of a situation where I would ever advise a sole proprietorship as opposed to an LLC or corporation, unless they just can't afford it at that time. So to do so, you go to sunbiz.org. That's the Florida Secretary of State Division of Corporations website, and you register your business with what's called your articles. And this is a public document. It's just going to list the name and addresses and at least one owner of the business. Another reason that deters people from registering is that each year the business that is registered, LLC or corporation, has to pay has to file and pay for an annual report. So the fees range from like $60 your first few years and go up to $150. And it's a really annoying fee because you don't really get anything out of it. It's just the state's fee for kind of maintaining records for the business, but those records they're maintaining are what is your liability protection. So it is important, if you miss the annual report, which is due typically May 1st of each year, they'll send a reminder to the email that you have on file every year, as well as a postcard to the address you have on file to remind you. So if you're keeping that information up to date with the state, again, on sunbiz.org, that's where you can find everything for that, then don't worry about forgetting, because they'll remind you. And if you don't pay that by May 1st, automatically, non-negotiably, they charge a $400 late fee. So you want to always make sure that that's done on time. And finally, you must file this isn't necessarily true, but on the surface, you must file a separate tax return for your business and not your individual tax return. However, this is something that you can always discuss with a CPA or tax professional, because you may be able to be a certain kind of entity, like an LLC, and receive that liability protection, but you can work with your tax professional to see if you could qualify to be taxed as a sole proprietorship. So actually your tax return will just be one, still very simple. But that's a little outside of my expertise. That's something you'll want to talk to a tax professional about. So that third prong at the top, must file a separate tax return, is generally true, but I would still check with a tax professional to see if you can get away with filing as a different type of entity. So again, you're paying these fees, you're having to do these things annually. These are the formalities I'm talking about. These are things partnerships and LLCs don't have to worry about. They're pretty much set up and can run business until the end of time and don't have to keep up with these filings or pay these annual filing fees, as well as some other additional formalities we'll talk about. But again, the protection that it gives you to register your business is so worth it. For a limited liability company, this is the most common choice for my small business owners, unless they have something more complex going on. If there's several owners, if there's different voting classes, meaning you want some people to only be able to vote on some matters, and normally small businesses and LLC is most appropriate. And in order to get that liability protection, first you'll have to register what's called the Articles of Organization on sunbiz.org, and the filing fee is $125. Second, you can have a single member LLC or a multiple member LLC. Either one, meaning you can have one owner or several owners. So even if it's just you, I would definitely still recommend, generally, not knowing the specific circumstances, that an LLC will still be very beneficial as opposed to a sole proprietorship. And if you have more members, even better. And then when I say members, a quick little vocabulary. Members are the owners of LLCs. Members run the managers run the day-to-day business. but you can be both. So you can be a managing member, meaning that you're an owner and you have authority to manage business on a day-to-day basis. Or you might have someone that's only interested in giving you money for your business, but doesn't want anything to do with actually running the business. Again, that's something you want in that internal operating document, because law will say, nope, you're both owners, or nope, you both have 50-50 responsibilities here. If someone's just giving you money and is acting more as an investor and isn't actually going to be running the business, they're only going to be a member. But if they're also allowed to, for example, enter contracts on behalf of the business, negotiate with third parties, then they're also a manager. So you can be just a member, just a manager, or a managing member. So if you're the only person involved in your LLC, you're going to be what's called the managing member. The LLC Operating Agreement is what when we talk about partnerships, and we called it a partnership agreement. We're going to, in that internal document, we're going to list how the partnerships actually run. The LLCs is called an operating agreement. You should draft an operating agreement that details operational and financial management of the company. So for example, how's the business going to pay taxes? Because as I said, there may be other ways more beneficial for you and your tax purposes, and you should consult with a tax professional to see how exactly is the best way for this entity to pay taxes. How will this entity distribute profits and losses between its members, between the people that are getting money out of the business? What are the voting rights? Does someone have more voting rights than someone else? Do certain members get to vote on some things but not others? And finally, how it's managed. The most common error I see is several people that got together and they knew that the liability protection was great, and so they registered an LLC. And then something happens a year, 5, 10 years later, and we're having to wonder who is a member, who is a manager. Did that individual actually have the right to, for example, kick somebody out of the business? You'll want to put exactly how to remove somebody from the business in the operating agreement. So what it is anticipating future problems. And I promise you, somewhere along the way, that something will come up with your business and you will wish you have had an operating agreement. So taking the time to sit down and not just say, here's what our minds think, how it's going to work, but hypothetically assume something's going to go wrong with the business and you're going to have to prove it to a judge exactly what your role is in it and what you are entitled to out of the business. I like LLCs better generally because they have less formalities than a corporation. And we'll talk about the little bit of formality more a corporation requires in the next couple of slides. But again, the benefits of an LLC. You are only liable for the debts and assets held by the LLC. So if your LLC goes under, it's going to be very difficult for a creditor to come after your personal bank account. The creditor can come after the business's bank account and the business's assets, so your office furniture, a car if you purchase it in the company's name, but they can't come after your family car and your family's bank accounts. Your personal debts and assets are held by you personally are separate. That's the key here, and that's why it's worth paying those registration fees and keeping up with those annual notices. The caveat here is that you don't want to what's called pierce the corporate veil. And this means that you are keeping up with those formalities. For example, if you are commingling your funds, this is the most common way you can pierce the corporate veil and lose liability protection. If your business is making money and you're putting it in your personal bank account and then spending it for business items out of your personal bank account, well, now you've kind of mushed everything together. Now the creditor is not really sure what's your personal bank account and what's your business's bank account. So the creditor is going to make the argument that you've pierced the corporate veil. You've lifted the corporate veil, and now people can see behind that veil the individuals running the LLC or the corporation. So you're going to want to make sure that you follow ethical rules as well as legal Florida statute rules. And one is that you shouldn't be commingling your funds.
Callie?
Yes.
I do have two questions related to this very topic. The first question is, can I put my business credit card with my personal check-in? Can I pay my business credit card, my personal check-in, or does that create a conflict? I think you just covered that.
Yes, I would say to not do that. What you can do and what a tax professional can help you with, or if you're balancing your own books right now, is you can reimburse yourself personally from the business, you know, and try to clear those transactions up to show that if someone were to look at the financial records of the business, that even if you did, because sometimes we forget our business credit card, or sometimes, you know, maybe the business is struggling and we need to use our personal assets to cover something for a few months. As long as you balance the books back out and show that really all the business assets and liabilities are separate from your individual assets and liabilities, that corrects it. But doing it on a day-to-day basis is a huge no-no. And sure, you're not, you know, I'm sure you're not doing anything intentionally wrong, but if a creditor were to come after you, or if someone were to slip and fall on your business, or someone were to sue you for breaching a contract, then those creditors or that person coming after you will make the argument that you were actually using your personal accounts for your business accounts, and that therefore they should be able to attach to either of them.
Okay, that's very good. I'm pretty sure that that might be the case. We have a lot of small businesses in here, and you know, sometimes people do what they have to, so to speak. So I'm pretty sure. I have one more question. It says, do I lose my LLC protection if are you good?
Yep, just plug in mine.
All right, no problem. Do I lose my LLC protection if I send money from my checking account to my business checking when I did not make enough income with my business? So for instance, they're transferring funds out of their checking account, personal, into business account. And that's sort of a commingling as well, like you described. But go ahead if you answer. So did you get the question? It shows that you are muted. Let me see if I can help you out there.
Sorry about that. I think I heard some static and muted it and then unmuted, and I couldn't unmute it myself. So, and like I said, you can certainly, sometimes we can't make ends meet, and that's going to be very common, happens all the time. At the end of the day, if you use that account, your personal account to, or your business account to pay yourself, or something from your personal account to pay your business, you're just going to want to make sure that soon after you reconcile those accounts, and you make sure that you're reimbursing yourself or reimbursing the business for whatever funds you utilized. One red flag here would be, though, is if you're taking deposits for clients, say you're in the business of building and you take $1,000 credit or $1,000 deposit from a client, or if you're in event planning and you take a credit from a client that's supposed to be used to purchase supplies or purchase rentals, that's not really your individual money. It's the business's money, and probably contractually you are being told what to do with that money. It's not really yours individually yet to be used to pay yourself from the profits. So if contractually you've earmarked funds for something, then you wouldn't be able to take those funds and put them in your personal account for any reason. That would be something that creditors can argue is commingling. But if it's just, you know, excess cash flow and it's not earmarked for anything, and you can reconcile the books later when things have gotten better, then that's something that I wouldn't recommend, but something you can fix. And if you need to do that for now, then do it for now and fix it later, if that makes sense.
Makes perfect sense. Thank you so much. I'm pretty sure that people right now during COVID-19 may have been, you know, experiencing that. All right. Thanks.
And then always feel free to keep interrupting with questions. So let me make sure. Yes, yes, yes. Okay. So moving on to briefly wrapped up, we talked about LLCs, making sure you have an operating agreement, especially if more than one individual is involved. And I just want to point out the story again. I'm sorry to repeat it, but it's the saddest story I have going on right now, where I have a client that is just trying to prove that he owns the business. And if he just had an operating agreement to start with, that would explain how the other partner in the business removed him from it without his permission when she filed the annual report. She pretty much just removed him as a managing member of the LLC. So, but there was no operating agreement to say how you can remove owners of the business, managing members, or nothing documenting that he put in certain funds and is an owner of the business. So really important to have that operating agreement. I can't tell you how many people don't take the time to do that, and it really backfires.
And Kelly, we have a few more questions, but just looking at the time, maybe some people probably have a hard stop at 1 or so, so I'll just leave them towards the end if that's, that's okay.
Perfect. And I only have a couple more slides, so we should be good.
All right.
Then a corporation like an LLC, this also has that limited liability protection we've been talking about, separating the business from yourself individually. The reason I like an LLC better is a corporation has slightly more formalities than just an LLC. So they both require an annual report. They both require you to pay and register a fee with the state. But a corporation has a little bit more. For example, you have to meet at least annually. So that's something that may pierce the corporate veil if the business, all the shareholders aren't meeting at least annually. You have to keep a record of corporate minutes and major decisions, and that's a lot of responsibility. Every time, say, you lease a commercial property or enter into an agreement with a third party, that should be something that's written down and put into the corporate minutes. And the corporate minutes are put into what's called a corporate book. It's not actually a book. Most people keep records of these things online now, but essentially it should be something that you sit down and can hand a bank or an investor or a potential buyer of your business, and they can flip through this hypothetical book and see all the major decisions that have been made. If you bring a new shareholder on, if you appoint somebody as a new officer, such as a vice president, and you have to have a board of directors. So these are things LLCs don't have, so it's just more formalities and more things to keep up with. So if you can have an LLC and there's not a good tax purpose for it, for a corporation, I generally recommend an LLC. However, it does have a smaller filing fee for the articles, only $70 instead of $120 for an LLC. So corporation terminology, owners are called shareholders, and the board of directors that runs the day-to-day business is called the board of directors. And you can be both. So you can be on the board of directors, meaning you run the show, and you can also be a shareholder, meaning you get dividends paid from the corporation, or you can be one or the other. And just like everything else, there should be an internal operating document that's called the bylaws. So the bylaws are just like the partnership agreement or the operating agreement. And that should detail the types of stock, if there's more than one type of stock, the rights of shareholders, when the annual meeting that's required has to be, things like that. And we already talked about taxation, and this is very, very far outside of my expertise, but what I can emphasize is that you should consult a tax professional, because just because you are a corporation doesn't mean you have to be taxed as one. You, for example, the most common form I said is an LLC taxed as a sole proprietorship or a partnership maybe. Legal entities have a choice about what tax entity they want to identify with is. So in other words, just because your entity is, for example, an LLC or corporation, doesn't mean you can't be taxed as something else. That could include C corporations, S corporations, and sole proprietorships. So it is a worth it investment to talk to a tax professional, which will be most beneficial to you. And just for the sake of time, I've already sort of went over this, so I'm going to skip over the taxation examples and conclude with our last topic, fictitious names, or what's called DBAs, doing business as. If you're operating any business, whether you're a sole proprietorship and you have to operate in your individual name, or if you're an LLC and you're operating as ABC LLC, but you go by blue pools, or if you're a sub, whatever you go by, if you're going by something that's not what's actually registered by the state, or if you're a sole proprietorship, what's not your individual name, you have to register what's called a fictitious name. And you do that on sunbiz.org. It's very easy to do. You don't need to hire an attorney to do it. You pay $50, and it just puts that name that you're using on notice to all consumers that that's actually yours, and they know who they're doing business with. So after you post the DBA with Sunbiz, you actually, this really, really stupid requirement under Florida statute, you're supposed to publish it in a newspaper in the county where you do business. So that is like a $50 to $100 fee. You can just Google it, how to post my fictitious name in a newspaper. They already have a form template that they'll use. It's just a silly requirement that Florida statute requires, but it is required if you want to register your fictitious name. And you have to renew the fictitious name every 5 years. Or if you sell the business or the business changes ownership, they can file a cancellation of it, or they have to re-register it within 30 days. So it renews every 5 years. You have to pay another fee, and whatever email address and snail mail physical address you have, they'll send reminders to that. And some interesting points about fictitious names that I commonly get asked. First, it does not, if you register a fictitious name, it does not reserve that name. If you want to reserve that name, you're going to have to trademark it, and you'll have to make sure that someone else isn't already using it and it's not causing a trademark infringement. And you can search that. There's a federal government website where you can search trademarks. But so if someone else has the same DBA you want to use, you can register it too, but it's not giving you exclusive right to that name. You do get exclusive right to your registered name, your LLC or corporate name, but not your DBA. Finally, if you can have several fictitious names, but all of the liability is under the one registered business, the LLC or corporation or sole proprietorship. So if you have 10 different DBAs, you don't get separate liability protection in each of those. It actually is still going under the overarching umbrella of the registered business. So if you want separate liability, you'll have to create a separate entity for each. For example, if you, a common way to strategize is if your business is, you sell puppies, and there's a lot of liability associated with breeding and selling puppies. And now your business is doing so well that you want to purchase a piece of commercial property where you're going to do your business and sell these puppies. You might consider, rather than just doing a DBA, you might consider establishing a whole separate new entity to hold the property in that, because there's a whole new slew of issues that come with owning property that have nothing to do with puppies. So don't just think that having a DBA is like having a separate entity. If you want to have separate liability protection for something that your business is doing, because there's something with a lot more and a lot different liability than what you're doing, even if it relates to your business, consider establishing a whole new entity rather than a DBA. So here is my contact information if you believe that you qualify for our free legal services, up to 140% of the area median income, or if I can send you more information about our program or a copy of the slides, please feel free to email me and I can get you any information. And again, happy to take any questions.
All right. Very, very interesting topic. I'm always interested to learn more about business entities as I work with small businesses and as my company personally grows. So thank you so much. We do have some more questions. Some of them are really quick ones, and then I believe others you could get into it a little bit more. So one quick question was, what is the date you need to file out for LLC again? So it says, so you had mentioned the date again already. It was May 31st, did you say? Or by May 1st?
I think it's either May 1st or May 31st, but that's when the annual report is due every year.
Right. So, and then this year, I believe that they gave an extension, right, Callie?
Yes. Due to COVID, they extended it to June 30th. So that date has already passed. But I think that's really the first time they've ever done that. And if you don't pay it by the day that's due, which despite COVID normally is May 1st, May 31st, then it incurs that automatic $400 late fee. So you can't say, oh my gosh, my grandma died, I was bankrupt, I was dealing with my child, I forgot to do it. They won't care what the reason is, even if it's a really good one, it'll automatically be incurred, and you'll either have to pay that fee, or if you don't pay that fee, a lot of times I just tell my clients to set up a new business because it's a lot less expensive than paying the $400 fee.
Okay, great. Thank you. I have another question and a follow-up one to that. It says, what are the tax implications of a LLC versus a corp? And then it says, what's a more favorable structure for tax purposes? Now, I know you mentioned you're not a tax professional, but as best as you can.
Sure. So from what again, I'm not a tax professional, so if it's just one person in an LLC, what I always recommend, generally always recommend without knowing the specifics, is an LLC taxed as a sole proprietorship. Because this has just been something tax professionals keeps coming up and telling me for years, because you get the benefits of liability protection, but you only have to fill out one tax return. You can also be taxed as a partnership, a C Corp, an S Corp. So I don't know the specifics of what is best, but that's why I think it's definitely worth the investment of a consultation with a tax professional or CPA so that they can tell you exactly what the best way to be taxed is, because sometimes it will save you so much money, even in the short run, that it will make paying that professional worth it, because you're going to be making even more because you're being taxed the best way. So I'm sorry I don't have more information on that, other than that I do think it's worth the consultation to find out the best way to be taxed.
Okay, great. Thank you for answering that. Another question. My partner and I own a LLC 50-50. When we want to adjust to 51%, 49%, so the business would be considered a woman-owned business. Mm-hmm. How do we do that?
So that's what the operating agreement should detail. Who is a managing member, or just a manager, or just a member, meaning who's just only an investor, and who actually has the authority to transact business on a day-to-day basis. So it should list out all of those roles and what everyone put into the business. Maybe you guys put in 50-50, but now you want to have it 51%, 49. That should be documented in the internal operating agreement. And then when someone asks, well, how do I know that it's woman-owned business? You can show them a copy of the operating agreement and say, here it is, I'm a 51% owner. And if you qualify for our services, that's certainly something we could draft for you.
Wow. That is such a great question. I encounter a lot of small businesses with that request or that need, because just knowing that there's so many benefits now for women-owned businesses. Mm-hmm. Thank you. There's another quick question. It says, do you need to submit percentages of ownership? And I think you went over that already.
Yeah, but it is a little confusing, because so you do have to, if you register with the state, you put at least one owner. I like to put all of the owners, anyone that has that is a managing member. I like to put all of them, because then it gives them authority to transact business without anyone having to look at your internal operating document. I just went off on a total tangent. What was the question? Oh, the percentage of ownership. But you don't have to register the percent of ownership with the state. So when you register with the state, they're going to ask the name of the business, who the owners are, what their addresses are, and that's it. And then where to remind you about the annual report. They'll ask for an email. But you don't have to list the specifics of who's doing what or what percentage of ownership there is. All of that nitty-gritty stuff is going to be in your internal operating document.
Okay, great. And I have a question that links directly to that too. It says, is it okay if we're both owners and considered managers in the application on Sunbiz, or do I need to change to say owners and managers?
have it say that you're both managing members, meaning you both have ownership, you act as owners or shareholders, and you both have the authority to transact business for the business on a day-to-day basis. So one of you can go out without the other one and be able to negotiate and even enter into a written agreement. So that's kind of what the purpose is of putting the owners on Sunbiz is, say you want to negotiate with me, you want to hire me as an attorney. I'm going to put your business in and look it up on Sunbiz, and I'm going to see that there's, and if you say that there's two owners but only one is listed, I'm going to probably advise you, I might advise you to add them because people want to know who they're contracting with, and it just makes that relationship more clear. Or if there's only, or both of you are listed on Sunbiz, it also gives you both as owners protection because I might want to be able to talk with both owners of the business, not just one, or at least meet them and know that they know what's going on in our negotiations. So I think that was a little longer of an answer than you were looking for, but I would list everyone that you want as a managing member.
And now, no, that's great. That's great information. Thank you. One more question is that I own an LLC with a partner who is overseas. Am I liable for anything that he does outside of the country?
So you can have non-U.S. citizens as managers or members in an LLC. What that person does overseas, certainly will depend on the laws of the country he's doing it in, and there'll be a whole slew of issues of them actually being able to get jurisdiction over you individually. But generally, yes, no matter that doesn't apply just outside the country, but anywhere. When you're in an LLC, whatever your other member managers do is a shared liability for the whole company, but not so much for you individually. So they're causing trouble for if whatever they're doing, if they do harm, they're doing it to the business, but at least you're in a limited liability company and it's not imputing to your individual assets or causing you individually to be liable for something, just the business. However, if you were a partnership and your partner was abroad or anywhere doing something illegal or unethical, then you might subject yourself both to individual liability. So another good example of why registering as an LLC or corporation is important.
Okay, great. Last question. And this is, we're going to talk about this in a minute. Last question, how can I trademark the name?
We are going to talk about that in one of our next webinar series, but it's pretty simple to do. We'll talk about it in more detail, but it requires a fee. Well, you can consider if you want to pay a smaller fee and only register it in the state of Florida, or a larger fee and register it nationwide. And if it's a really long answer because it will take some time, but if you want to join us is that the next one, Sidonie, in 2 weeks, or is that the last one?
So that would be the last one on August 20th. Next time we speak about commercial leases.
Okay, so we will talk about intellectual property in more depth, but for now, just know it's a pretty simple process. You just want to make sure that your logo is something that's easily, readily different, that no one can mistake for another business. And you'll want to have some examples of how you use it, for example, on your business card, on a poster, and we'll actually present all that stuff to the state, and they'll have copies of all that, and then anyone tries to use that exact mark or something that looks generally like it, that would be an infringement. So we will, so Sidonie just put up the flyer all the way to the right, Thursday, August 20th. We'll talk about trademarking and other intellectual property concepts in more depth.
Wonderful. So this has been pretty helpful. I have one last poll, just asking everyone basically how they found the session today. We want to continue to bring you good information. I'll give you one more second. Oh, it looks like others are still voting. All right. Awesome.
Well, thank you everyone for being here, and thank you, Sidoni, for putting this on. As I mentioned 2 weeks ago, I love doing this. My job is to prevent people from ever being in a situation where there's litigation or fight with a partner or something that's not clear about your business, because it's your livelihood, and it's really important to take the time and spell things out and put it in writing. And hopefully some of you qualify for our free legal services, because it's so worth it. If you don't, I suggest doing research, hiring an attorney if you can, because it's just better to sleep at night knowing when everything's taken care of at the beginning.
Yes, absolutely. And do remember that you can always reach out to us if you need any assistance, including legal aid. I look forward to helping you with that. Our next session, like I said, is August 6th, which is 2 weeks from now at the same time, 12 o'clock. And it was my pleasure. So thank you, Callan. Thank you, the Black Swan team in the background, for everyone that's doing such a great job. And everyone, have a wonderful, wonderful rest of your day. We'll see you in 2 weeks.
Thanks, everybody. Bye.
Thank you. Bye-bye.